Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Hello, everyone. Welcome to the Baker Botts Enforcement Insider, a podcast covering the latest trends and developments in compliance and enforcement with a focus on the energy and technology industries. As you may have noticed, we've branched out a bit recently. We were formerly called the Energy Enforcement Insider. And while energy is certainly still part of our core focus, we wanted to make the aperture of the podcast a little bit wider to reflect the work we do in technology and other industries and to capture the compliance and enforcement developments we see going on there as well as energy. So we're really excited about this change. And with me, as always, is Brendan Quigley, and I'm Michael Loesch. Brendan, how are you doing today?
Good, Michael. How are you?
Good, good. Look, today I think we're going to focus on insider trading issues and developments in one particular recent case that I think there's been some good discussion about in compliance circles, but one that we haven't really focused on yet. Do you want to jump into that, Brendan?
Sure. Yeah, I'm happy to talk about it. Insider trading, kind of apropos of our widening the aperture, is not specific to any one industry. Certainly affects that's something that compliance professionals and in-house counsel get questions about, and that comes up across the board. And we're going to talk today about the recent SEC, what was called the shadow trading prosecution and enforcement action, and kind of what implications that has for corporate compliance policies, for non-disclosure policies, and things of that nature. I think it's important just to step back before we delve into the details of that case and talk about what is insider trading and how and why it's prohibited, because I think that will inform both our discussion of the case and then the takeaways that we will have. And I think one thing that's important to know is, at least under the securities laws, there's no statute or rule that explicitly prohibits insider trading. That doesn't make it okay, but instead the SEC enforcement actions and DOJ prosecutions, most of them over the last 50 plus years, have been brought under Section 10B of the Exchange Act and Rule 10b-5, which, as most folks know, generally prohibit fraud and deception in connection with the purchase or sale of a security. And there are lots of issues surrounding this. Lots of case law has been spilled and come out over the year. Lots of ink has been spilled in client alerts and on CLE panels about different aspects of how we got from Rule 10b-5 to insider trading. But I think bottom line is that the Supreme Court and the federal courts of appeal, and in particular the Second Circuit, which has been one of the leaders in this area, have held that it's fraudulent under Section 10b and Rule 10b-5 for a person to trade on the basis of material non-public information in violation of a duty of trust and confidence, either the shareholders of the company, if they're a corporate insider, it's called the classical theory of insider trading, or to the source of the information. That's called the misappropriation theory of insider trading. And typically, most insider trading cases have involved trading or tipping by the defendant of the securities of their own employer or of a company to whom he or she owed a duty of confidentiality, either because of a professional relationship, like an attorney-client relationship, or because of a specific confidentiality agreement, like an NDA or something like that. So that brings us to the case we want to talk about. And recently, however, the SEC brought, and in fact won after trial, a case in which a defendant was alleged to have traded not in the securities of his company, but in the securities of another company in the same industry, albeit based on material non-public information he had received from his company. And that case is called SEC v. Pamuwat, Panuwat, and was brought in the Northern District of California back in 2021, and it went to trial earlier this year. A relatively rare SEC civil insider trading trial.
Before we get into what happened in the Panuwat case on the SEC side, it's just worth noting that the CFTC, the Commodity Futures Trading Commission, also has post Dodd-Frank been pursuing what some refer to as insider trading enforcement actions, really based on the misappropriation of material non-public information. They've been slowly expanding their enforcement efforts in that area. They haven't yet gotten to the shadow trading or equivalent action similar to what we're going to talk about with Panawat, but they are. It's definitely worth, as you're thinking about and as we're going through this SEC scenario, to consider risks and issues on the commodity side as well.
Yep, I think that's right. And I think a lot of the non-disclosure issues and confidentiality agreement issues that we'll talk about, and the takeaways could apply across the board, regardless of what regulatory agency you're dealing with. So in Pamuat itself, like I said, case filed by the SEC in 2021 and tried to a verdict earlier this year. The SEC alleged that Mr. Pamuat was an employee of a mid-cap oncology-focused biopharmaceutical company, which we'll call Company A. And that in his role at Company A, he had learned material non-public information that Company A was going to be acquired by a much larger pharmaceutical company. As alleged, Mr. Pamuat then went out and bought short-term, out-of-the-money call options, so options to buy, not of Company A, which is the typical fact pattern in a lot of these cases, or even of the large pharmaceutical company, but of Company B, which was another mid-cap oncology-focused biopharmaceutical company, and what the SEC described in its complaint as, quote, another comparable public company, end quote, in the same industry. And so as part of the breach of duty element, which we previously discussed, breach of a duty of trust to the source of the information, here, Mr. Pamuat's own employer, the SEC noted that Company A's insider trading policy prohibited, quote, buying or selling or in some other way dealing in the company's securities, so far pretty standard, but then, or the securities of another publicly traded company on the basis of material non-public information an employee had received through his or her employment at Company A. A little broader than often seen in that it prohibited not only trading in the basis of your employer's information, but also in the securities of another publicly traded company, which is pretty broad. Pamuat moved to dismiss the SEC's complaint. The court denied that motion in early 2022. We actually wrote a client alert about it at that time, which we'll link to in the show notes. And then the court later denied Pamuat's motion for summary judgment. In denying those motions and finding that the SEC had sufficiently alleged that Pamuat breached his duties to his employer, Company A, the court focused on a number of things. And the first thing was that insider trading policy that we just mentioned, where he was prohibited not only from trading, and again, his own company stock, but also in the securities of any other publicly traded company, to the extent that trading was based on material non-public information he gained through his employment at Company A. And further, SEC alleged that the discovery supported the theory that the information that Pamuat used to trade was, in fact, Company A's confidential information about the potential acquisition. There was not insignificant evidence about the timing of these trades compared to some meetings he had at Company A, as is often the case in insider trading cases, that at least the ones that get to trial. The court also rejected the argument that the information was not material. Materiality is often a fact question, very difficult to win on a motion to dismiss on materiality. But the court focused on the market connection between Company A and Company B. It noted there were a limited number of mid-cap oncology-focused biopharmaceutical companies with commercial stage drugs at the time, such that a potential acquisition of Company A would make Company B and other similarly situated companies more attractive. So the way the SEC framed this was that these companies were a pretty tight group within a particular industry, making a particular product that was at a particular stage of development. So the case proceeded to trial last month, and a jury in the Northern District of California found Pamuat liable. I believe that there is an appeal, and I think, as most appeals do, the jury's verdict will be entitled to significant deference. but I think I'm sure the Ninth Circuit will take a close look at the court's rulings on the motion to dismiss and the summary judgment, as well as the jury instructions at trial. And those things can get a closer look by an appellate court, particularly around, I think, the materiality instruction and some of the other kind of somewhat novel, although the SEC has gone to great lengths to say this case was not novel, some of the other novel aspects of this case.
What do we think some of the takeaways are from this? It's still not final on appeal, but I guess a significant win for the SEC on a theory that I think, notwithstanding the commission's view that its ordinary course is really an expansion and a novel approach. What are some of the key takeaways in your mind?
Yeah, so I think like in any successful outcome for the SEC, pending appeal, this will be an area that the SEC now looks at and looks at more closely. I think any fair notice requirement that Mr. Pomuad had is going to be a more difficult argument, without saying it's an impossible argument, will be a more difficult argument to make in subsequent investigations and enforcement actions. And I think one of the takeaways for in-house folks and compliance officers is it may be good to examine your company's insider trading policy and what does it prohibit, right? Does it prohibit just trading in the company securities, or does it prohibit, like the one in Pomuad's case, trading on the basis of material non-public information in both the company securities or in the securities of any other publicly traded company, or is it somewhere in the middle of those two things? And I think, there's not necessarily a right answer to which of those options you need to take. However, it is important to make sure that your employees are aware of what exactly the policy prohibits.
Yeah. I think that gets to the need to re-examine your training, right? Ensure that your annual training or regular training related to insider trading and other related documents cover this fact pattern and address specifically any formulation, the actual formulation in the company's policies, so that there's a clear understanding on the part of employees as to what the implications are for their trading activity.
Yep, I think that's definitely a takeaway. And then I think, I think the materiality piece was important. I think it's important to note that the SEC was able to frame this in a fairly tight way in terms of materiality. Mid-cap oncology-focused biopharmaceutical companies with commercial stage drugs at a particular point in time. Not every case is going to be that kind of granular, but again, as you said, Michael, it's really a matter of capturing this fact pattern in your training, in your internal learnings, and making sure that folks are aware of it and seeing how your policy, your insider trading policy, your non-disclosure policies are affected by it. Anything else, Michael, on insider trading today?
No, I think we should keep this short. I think this is an important case in fact pattern for people to be cognizant of and to begin to factor into their training and compliance policies. I think, as I mentioned at the start, the CFTC remains active in pursuing enforcement related to misappropriation in the commodities markets, and we'll pick that up in a future episode. There's some recent enforcement actions out of the CFTC related to misappropriation that are worth going through, but let's pick that up in another episode, and that's all for now.
Thank you, Michael, as always, and we'll talk to everybody in a few weeks.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.